Ladies and gentlemen, my guest today is not just a renowned jurist but also a former Chief Justice of India. He still very recently occupied that chair, was part of some very consequential decisions, and it is generally believed, and independent observers say, that during his time he did move the Supreme Court towards a lot of administrative reforms and alacrity. Justice Lalit, welcome to NDTV.
Thank you. Thank you.
Justice Lalit, I just wish to ask you to begin with one question. That in a rare occurrence, Parliament is going to debate, at least they have agreed upon, a constitution debate, a debate on constitution of this country. Tell me one thing, is it a good thing or is it a bad thing?
There are certainly good features about it. See, every now and then, those persons who really matter, and when it comes to constitutional aspirations, goals, and what exactly would be the account as to what we have been able to achieve up till now, perhaps the best and there can't be anything better than that. The body would be the Parliament.
So you think it's a good thing?
If the parliamentarians quite periodically keep on taking this account or stock-taking situation as to where exactly do we stand, how far have we come, whether there are any provisions which require any amendment, or whether any amendments which had been effected up till now, whether those amendments need any kind of fresh reading. So therefore, this kind of introspection is something which is always welcome. So if the parliamentarians wish to do that kind of introspection on the achievements on the constitutional front, then it's a very, very welcome idea. Yes.
And my second question to you would be that in terms of the aspiration or the lives of the common people, common men, common ordinary citizens of this country, how do you think, of course, it is the role of the judiciary, you occupied the apex of it, to interpret various features of the Constitution in relation to the provisions in the Constitution, freedom of an individual, freedom of expression, those are the critical features of a democracy. How do you think our Constitution has fared so far?
It has fared very, very well. Of course, the judicial interpretation also helped us. In the initial case, the first case, which was A.K. Gopalan, one of the arguments which were advanced on behalf of the petitioner were that when you consider and interpret the expression except in accordance with procedure established by law in Article 21, do you simply go by the procedure as stated in the law, or would it be also open to see whether that procedure is fair or not? That is to say, read quote unquote expression due process in that particular article. It took us some time for the Supreme Court to accept that, and in Maneka Gandhi we came out with what is called the expanded definition of right to life. It is that expanded definition of right to life which was responsible for our reading a typical right flowing from Article 21. That is to say that every child in this country in the age group of 6 to 14 will have a fundamental right to be educated and to be imparted free, compulsory, and good quality education. This is something which the Supreme Court stated in 1993. So therefore, in about 9 years' time, the Parliament came out with an amendment and Article 21 capital A got inserted. So these kind of developments always augur that very well the change is something which we always aspire for. Change for the betterment, change for the better lives of people. So therefore, if you study the constitution, we have lost one fundamental right, which is right to property, but we gained one fundamental right, which is the right of every child in this country to have free and compulsory education. Have we really lost on account of that right to property not being in part 3? Nothing much. It hasn't changed the spectrum so far as the entire population or the general people are concerned. But right to life getting inserted in part 3, it has had tremendous dimension so far as the development of this country is concerned, giving substance to everybody's life. And since last 2002, the right has been inserted. For last 22, take it that at least 2 generations of students have passed out with the help of that kind of facility afforded by that right. So we are definitely moving towards betterment, moving towards good ideas getting inserted in the constitution, some of the fabulous ideas getting incorporated through interpretative process, and even now amendments as well. Now the last amendment, which is 106th amendment, now gives the women one third of these seats in Lok Sabha and in every state legislature. We are moving towards what is called inclusive ideas on every front. So therefore, that's a very, very nice idea.
And my final question to you, Chief Justice Lalit, before I let you go, is that many people say that while our constitution has been amended so many times in such a brief period of 75 years, the same fate has not been met by many other constitutions in the world. So why are we amending so fast? Is it to satiate the needs of a developing country, a developing nation, and a nation of mega population? Or do you think we are very quick to amend the constitution? In fact, Supreme Court has said on many occasions that constitution is a living document. It is not something that is cast in stone, so hence it is can't be changed. It is a living document impacting the people's lives every day. Now, while that is understood, the criticism is also this, that there are far too many amendments to our constitution compared to other constitutions of the world.
Not so many. If you actually look at the substantive amendments, there are very few. We have come up to level of 106 amendments. Correct. 4 new areas got included in the union, like Dadra, Nagar Haveli, Pondicherry, Yanam, Karaikal, then Goa, Daman and Diu, and finally Sikkim. So therefore, some of these amendments are more or less, the procedural part, nothing substantive. Substantive amendments, if you put your fingers on, there may be just about 7 to 8 substantive amendments. So therefore, otherwise, every amendment there have been results as perhaps I think response towards some of the judgments given by the Supreme Court. Say, for instance, Indira Sani said that no reservation in promotion. There was one amendment was required. Then there was a lot of debate whether it is consequential seniority or the original seniority. So therefore, one more amendment came into effect. Then another amendment whether backlog vacancies can be filled in or not. So therefore, these are some of the amendments which have been actually effected basically to refine the process. So therefore, some of the rough edges which were there in the process have been now sort of smoothened and the process becomes completely easy. So therefore, yes, there have been amendments, but to my mind, those amendments were required, were necessary, and they have actually galvanized our country towards the path of development. So therefore, nothing wrong in that. There have been amendments, and our constitution has to have that kind of elasticity to accommodate these kind of amendments. Now, take for instance 73rd and 74th Amendment. We wanted to have the unified ideas so far as Panchayat Raj is concerned, at Panchayat levels, at municipal levels. So therefore, this is how we have been moving towards We are learning from experiences, and those experiences are now getting sort of solidified in our constitutional jurisprudence. So, therefore, nothing wrong in that. That's absolutely perfect.
Thank you, Justice Lalit. Thank you very much for
Thank you
joining
so much.
NDTV.
Thank you. Thank you. Thank you.